This meeting is being recorded.
Great. Sirpa, you have the floor. Thank you.
Thank you, Gabriel. Good morning, everybody, and welcome to the NHRI webinar on strengthening human rights accountability at borders. I will just briefly introduce what we are going to discuss today. But first of all, I would like to, of course, thank NHRI and especially the working group on asylum and migration, who has been producing excellent work on border accountability and on asylum migration issues in general. I think we are living in times in Europe where this topic is more important and sadly also more difficult probably than ever before, at least during our generation's lifetime. And since 4 months we have had war in Ukraine, the aggression by the Russian Federation. We have huge numbers of refugees, I think only from Ukraine, 8 million. And what we also see, and this applies in particular also in my country, so general securitization and militarization of border regimes and also the societies in general. Just tomorrow, the Finnish Parliament is going to enact a law which will be in violation of both the European Convention on Human Rights and European Union law, Charter on Fundamental Rights, basically giving a possibility to completely close our eastern border 1,300 kilometers. So this is very, very peculiar times when these kind of things are happening and generally supported by even a liberal government. So it's very timely to discuss these issues to see what can we do in our national capacities as NHRIs, but also jointly as NHRI and together with other actors. And therefore, I think the new report, which will be launched, is extremely important and will give us a way forward on how to tackle these obstacles, how to use the openings and the opportunities presented, and then also see how could we work more effectively together to ensure access to the borders, access to the procedures, humane treatment, and also respect for human rights at the borders and more broadly also then in countries. So I will not go more into the substance since we have colleagues who will be introducing the topic. But it is important that we will hear a broad variety of perspectives, not only NHRIs, but our international partners, also civil society, and also we will hear from refugees and migrants themselves. So I look forward to an interesting webinar, very important. And with these short opening remarks, I would like to give the floor to Eva Zavala, who is the chair of the NHRI Working Group on Asylum and Migration from the Greek NHRI, with, of course, huge experience directly with dealing with these situations in Greece and within the working group. So Eva, the floor is yours.
Thank you, Chair, for your kind words on the work of the Asylum and Migration Working Group, and as well as for giving us the broader context of this discussion today on accountability at borders. And it is, of course, with great pleasure that today I will present you the key findings of this upcoming report, NHRI report on strengthening human rights accountability at borders. This is an outcome of a project that we are working on the past few months at the working group. And also happy to see some colleagues present here today that have actively contributed to this result. And also would like to thank NHRI Secretariat and of course our external consultants and partners who have provided feedback and to achieve this report, this result. We strongly believe that Christos, can we start with the PowerPoint, please? Yeah. Thank you. Yeah, okay. We strongly believe that while monitoring and reporting can be powerful tools, and NHRIs indeed have extensively used them in migration-related matters, they are not enough. And based on the findings of our last year reports, you see here the previous report on migrants' rights at borders, we found that despite the increased evidence of human rights violations at borders, and this is a common finding from several actors, not just NHRIs working at borders, this has not led, unfortunately, as you know, to stronger accountability for the violations recorded. And why is that? The previous slide, please. Yeah, why is that? This is where our next report came in, as you see the gaps in human rights accountability at borders, where we identified the gaps in accountability, and understanding the gaps, it was the first step in order to find solutions that we will present today. The previous report was published last December, and the upcoming report will be published during July. NHRIs have a unique role, a specific mandate to contribute to strengthening accountability for human rights at borders. As you know, we work with authorities advising them in relation to international and regional human rights standards. We are vested by law, by constitution, with specific powers on monitoring or even investigating violations. And we have access to border areas, to detention, reception facilities, and much more. But while protection and promotion of human rights is, of course, our let's say, primary or unique mandate and role, we are not alone in this effort. Our work is complementary to other actors working on the effective enjoyment of human rights, and especially migrants' rights, since we're talking about migration, on the effective enjoyment of rights by the rights holders themselves. And we are very happy to have you here today to present also your feedback and experience in this aspect. Next slide. We are moving now to presenting you the key outcomes, the 5 elements that we have identified as key outcomes towards the strengthening of the accountability at borders. So first, it's independent and effective monitoring and reporting, in line, of course, with international standards and obligations. Access to justice, which is guaranteed both in theory and in practice. As we know, this includes the operation of effective, independent, accessible complaints mechanisms. The third one is independent investigations, independent, of course, but also they must ensure that victims are heard, that perpetrators are brought into justice, they are identified, and that sanctions are being implemented. The fourth key element is revision of practices, policies, and legislation to ensure compliance with human rights standards and prevent, this is also a concern, to prevent future human rights violations. And the fifth one, a culture of respect for human rights, which is achieved mainly through trainings, but with the participation and inclusion, let's say, of all actors, human rights defenders also. So how to achieve them? These are the keys, let's say, to unlock this dysfunctional accountability, national accountability systems that we see in practice. Next slide, please. The proposals based on our experiences. In our previous report, we have identified structural gaps in monitoring and overall transparency. Here are some solutions, recommendations, how to overcome them. First, to guarantee and strengthen human rights monitoring. Second, to strengthen accountability for cross-border violations. This is important, the cross-border nature. Third one, the border management must be more transparent, let's say. And the last one, to guarantee public scrutiny, which is linked also to transparency of readmission agreements. And since my time is quite limited today, I cannot go into details of each one, but of course you will see, you have a comprehensive analysis of these recommendations with examples included. This is also our added value examples from NHRIs national practices in the forthcoming report. Next slide. Then another gap, human rights accountability at borders requires that migrants have effective access to justice. How to secure effective access to justice? Here are some solutions: access to tailoring information and also to linguistic assistance, ensuring the accessibility and quality of legal aid, building trust in the accountability systems. Next slide. Another gap that we have identified and we try to remedy is that independent investigations capable of identifying and sanctioning perpetrators are, of course, vital for this accountability system. And we know, based on common findings, that while complaints procedures are in place, in practice, very few investigations are being carried out. And how to overcome these obstacles? By gathering and presenting evidence human rights violations and by facilitating these effective and independent investigations. And we can also, of course, anytime we can come back into analyzing more in detail in the Q&A session, if you wish so. Next slide, please. A strong accountability system should have a preventing effect. I've already mentioned this preventing aspect that we're much interested in. And where necessary, it should lead to the revision of laws and practices that contravene states' human rights obligations. We have found that there is in law provisions that contravene the obligations from EU and international law. And so states are recommended to implement the recommendation of NHRIs and other human rights defenders, but most importantly, also to implement the court's decisions, national and regional judgments. And finally, a culture of respect for human rights, as I've told you, is a cornerstone of upholding human rights, accountability, and this is particularly significant with respect, as you understand, to law enforcement agents who work at border areas, and national and regional authorities can together find a solution to promote the primacy of human rights, as I told you, by trainings or other type of synergies that you will see in our report. So next slide. Moving now to the key messages that we would like to put more emphasis today and maybe launch a discussion afterwards. These are messages addressed to regional and national actors, as I told you, regarding strengthening the human rights accountability, but also preventing human rights violations. And based on our findings and expertise, we would like to highlight the following. The first key message: accountability at borders requires proactive steps to end this climate of impunity that is now prevailing at borders. National and regional actors should act, as we told, proactively. What does it mean? They should no longer turn a blind eye, let's say, to well-recorded violations. They must take their human rights obligations seriously. States, we have already recommended that. And for instance, to give you some examples, states that need to provide adequate resources and funding for NHRIs and other human rights defenders to support their work at borders, protection work, but also facilitating access to justice for the victims of violations. Another example, national and regional authorities, such as EU agencies that they are now operating in borders, should respect mandate of other human rights bodies and work constructively with them. Okay, respect, but also cooperation and coordination among stakeholders is, according to us, a key to prevention. Then the second key message is EU legislation and policy must contribute to bridging accountability gaps. In the European Union, as you know, the past few years, the European Commission has launched many initiatives and proposals to try and harmonize even more the different national systems on asylum, reception, returns, and more. There has been already an agreement on certain points, such as the role of the EUAA, while other proposals affecting the situation at borders are currently under discussion. And the outcome of these negotiations at the EU level will have, of course, a bearing on the level of human rights accountability at borders. So we advise the EU institutions to strengthen, through their the new adopted laws and policies, to strengthen this human rights accountability system and not to weaken the protection afforded to migrants at borders. And also the European Commission has launched this evaluation, the rule of law review cycle and the Schengen evaluation monitoring mechanism. And we believe that NHRIs have a role to play as stakeholders and partners to this review and evaluation of human rights situation at borders. And also at national levels, of course, it's the same applies. Parliaments of other public authorities should consider accountability at borders central to their evaluation of the rule of law. I'm now have moved to the third key message, which must be the accountability must be considered part of the general rule of law, the general principle of respect of the rule of law. And we have strongly recommended in previous reports also that These two are closely interlinked. Human rights accountability and the rule of law are closely interlinked. When we have a strong rule of law regime, we have effective protection of human rights, and when the rule of law can only be fully realized in an environment that protects human rights. The fourth message, cross-border violations required for cross-border solutions. Okay, is this evident? Yes. Is it implemented in practice? No. And why? Because, okay, this is not an easy task. We have said coordination at borders between national stakeholders is key, and coordination and cooperation between cross-border organizations and states is also key. And this is very crucial because sometimes violations are of cross-border nature, and the victim is now situated in the jurisdiction of another state. And NHRIs have some good practices to showcase in this regard how we can work towards cross-border cooperation on strengthening accountability. And the fifth message is lessons learned from the response to forced displacement from Ukraine, as also the chair mentioned. We should take into consideration the context of and the treatment of people fleeing Ukraine, and the response, the positive response that we acknowledge coming from the EU institutions and the European states themselves. And indeed, we have seen that indeed a human rights based and protection sensitive approach is feasible, is possible. Let's keep this momentum and expand it to all migrants at all borders, and that they arrive from different countries of origin and irrespectively of their race or ethnicity. Thank you very much for your attention. And Gabriel Almeida, you have the floor.
Thank you very much, Eva, for this very clear presentation of our upcoming reports. And we really welcome all of you to read it once it's out, but also to consider how it can reinforce your own messages and how we can work together. I would also like to thank Sirpa Raucho, the chair of NHRI and the director of the Finnish Human Rights Center, for bringing her expertise, but also for her leadership at NHRI. And indeed, the NHRI board has decided to continue to prioritize migration, also in relation to the displacement from Ukraine, in the work of NHRI for this and next year. And I think that's very important. Well, we're now going to continue our conversation. I think it became quite clear that stronger accountability at borders cannot be achieved by one actor alone. In fact, different actors play different roles and must work together so we can prevent the future violations occur, but also ensure that when they do occur, that there are investigations and remedies in place. So we will hear from different actors in this first and second panel that I'm going to moderate. Just for the participants, if you have any questions, please write them down, keep them in mind, because after the second panel, we will open for a debate and questions and answers. So, so you have a chance as well to participate. You can do so either by indicating in the chat or raising your hand when we come to that part of the webinar. Well, I'll now move to our first panelist, and I'm delighted to give the floor to Dr. Hanna Machinska. She's the Deputy Commissioner at the Office of the Polish Commissioner for Human Rights, that is the Polish NHRI, and she has extensive knowledge in the field of migration, but also non-discrimination. And she's been a central figure in the Polish NHRI's work in relation to the violations not only at the Ukrainian-Polish border, but also the Belarus border. So I couldn't think of a better person to exemplify the important work that NHRIs are doing in Europe in that field. So Hanna, I'll give you the floor for 8 minutes, and you get a notification when your time is about to end. Thank you so much.
Thank you very much. Thank you very much for the invitation. Well, I think that nowadays the issue of migration is absolutely topical in Poland. And for us, the Commissioner for Human Rights Office, the protection of human rights addressed to refugees is absolutely priority. So we have two pictures of the situation. The first one is the Polish-Ukrainian border, when we found quite transparent procedure, hospitality, equal rights of Ukrainians and Poles as far as the access to the labor market, education, social services, housing, which, well, of course, we can find some problems in this respect, but there is a totally different picture at the Polish-Belarusian border. We know very well that the situation is the result of provocation of Ms. Lukashenko and Putin, and well, this influx of migrants, totally unaware about the situation, well, needs a proper response. A proper response means that, well, they should be treated according to the international and Polish standards as far as the human rights are concerned. And, well, the main issue is, of course, the first, well, what we raise in the Commissioner Office is to implementation of Geneva Convention and European Convention on Human Rights. At the moment, we have quite difficult picture, because we found that Belarusians, well, they treat, well, the border guard on the side of Belarusian, they treat migrants in a very cruel way. I mean that, well, they are very often victims of torture, and when they try to cross the border, well, on the side of the Polish border, guard border, well, they found a very cruel treatment. Cruel treatment means that the border guards, according to the Polish law, but not to the constitution, they use pushback. Pushback is the main instrument, and the Commissioner for Human Rights, from the very beginning, he expressed clearly his view that pushbacks is totally in legal form. Just to give you an example, recently, based on the recommendation of Mrs. Dunia Mijatovic, well, the commissioner addressed a letter to the Prime Minister saying that, well, this recommendation should be implemented in Poland, and the legal framework is totally in total contradiction to the European and, well, European standards. So we found, let's say, many actors in this procedure. Well, first of all, if at least in some kind of difficult moment, the refugees manage to cross the border, then if they are found by the border guard, so immediately, as I said, pushback is used, and there is no absolutely other, let's say, forms until the very moment if they present interim measures from the European Court of Human Rights. So interim measures, it's still a very good safeguards for them. Interim measures of the European Court of Human Rights. So there are families, we found families, 30 times pushbacks, and, well, in a total dramatic health situation. So legal framework is something what should be definitely changed, and this is our position. The second, if they manage to cross, well, there is another, let's say, actor in this process. So the border guard can ask the court to place the people in the guarded center or to use alternative measures. And in 90%, the courts decided to place families, children in the guarded center. Recently, National Preventive Mechanism presented a very good report on the situation in the guarded center. It will be translated probably in the next week into English. So, well, the commissioner, in this respect, the commissioner plays a very important role, because from the very beginning, we managed to visit all restrictive zones. Remember that Poland declared the emergency state, and the only institution with a full access, it was the commissioner. So our picture, our monitoring, of course, is very limited, because we cannot be present every day. Nowadays, well, this emergency state and this restriction has been removed. So there is an access to NGOs, to lawyers, to different stakeholders. So the transparency of the situation, of the actions taken at the border is really very limited. Of course, we collect information from the lawyers, activists. The activist plays an absolutely fundamental role. So nowadays, when the commissioner decided to send a letter to 22 regional courts, informing them about the situation in the guarded center, well, we notice a small change in the practice of the courts. So step by step, the courts decided to use alternative measures, not the guarded centers. Then the Supreme Administrative Court, on the motion presented by the Ombudsman, said that pushbacks are illegal, that the pushbacks, there is lack of humanitarian approach, and many first instance courts also change the position, saying that, well, it is absolutely crucial to use alternative measures, to individualize the procedures and according to international standards. So our problems at the moment are following: that legal framework violating international standards, practice of the border guard violating international humanitarian standards. We have also a very serious problem with the implementation of the judgment of the European Court of Human Rights. A few days ago, a Polish Ministry of Foreign Affairs sent a letter to the European Court of Human Rights, informing the Court of Human Rights that Poland will not implement the judgment of the European Convention based on Article 6. And that this Article 6 of the European Convention is in contradiction to Polish constitution. This was a decision of so-called constitutional tribunal in Poland. So this is a absolutely shocking for all of us decision, and it will have a very strong implications. Well, another problem, as you know, this is a rule of law, which is a very serious challenge for Poland. There are many judgments, and if the case comes to the court, so there is a reflection about the impartiality of judges, independence of the court. Until now, in the area of migration, let's say migration, refugees problem, well, we can fully rely on the courts, what they need. They need definitely more information, and well, they should use, they should apply international standards, and they should apply directly the European Convention of Human Rights. So the last sentence is that the Commissioner in this dramatic situation, the Commissioner for Human Rights plays absolutely fundamental role, and well, it is fully independent body, quite clear in our opinion about the violation of human rights at the border and Belarusian border, and even recently we have yesterday we learned about the person waiting for the permission to cross the border in an official legal checking point in Terespol, and there is a problem with the border guard. So thank you very much for the report. Your report is, you know, a very important, very important, let's say, material of reference, and well, we will distribute this report. We will use this report in our practice. Thank you very much.
Thank you so much, Hannah, for this very clear presentation, but also strong message on the importance of NHRIs, but also other actors, not only through monitoring, but relying on the courts. And it's unfortunately, as you said, a dramatic situation when we think about accountability at borders and accountability in general, the Polish situation. So thank you so much for telling us more about that. I'm sure you could tell us much more, but unfortunately we need to move to our next speaker. And I'm actually delighted to give the floor to Birgit van Hout, the regional representative for Europe of the UN Human Rights Office. Many of you will know her from her work in Brussels and in Europe as a leading voice in calling for human rights protection in our region, but her office has also been very involved in monitoring, but also speaking out in relation to developments of migration at the national, but also the EU level. So Birgit, thank you so much. I'll give you the floor now for 8 minutes, and you get the warning when your time is close. Thank you so much.
Thank you, Gabriel, and dear participants, good morning to all. I would really like to congratulate Eva and NHRIs Asylum and Migration Working Group on its excellent paper and report on human rights accountability at borders. I'm very pleased to contribute to UN Human Rights Office's perspective on this matter. Accountability in human rights terms means responsibility, answerability, and enforcement. Accountability is a key principle of the human rights-based approach. And while states have the sovereign prerogative, of course, to define their migration policies, they must do so in full respect of their human rights obligations. Borders are not zones of exemption from human rights obligations. As right holders, migrants and refugees are entitled to accountability by states as duty bearers. Human rights and border management should, can, and must go hand in hand. The UN has several mechanisms that assess states' compliance with the international legal obligations. And let's not forget that states have voluntarily contracted these obligations. And the dialogue between these mechanisms and the states as duty bearers constitutes in and of itself a form of accountability. So this is what I will be talking about. Let me start with the Universal Periodic Review of the UN Human Rights Council. It's also known as UPR. It is a peer-to-peer process by which states make recommendations to each other on how to improve human rights or improve on human rights. And although it is an inherently political process, the UPR has proven quite useful because states have demonstrated a very distinct sensitivity, I would say, to recommendations made by their peers. And furthermore, the process enjoys very broad buy-in. Unfortunately, the UPR recommendations to states on migration are quite generic, and NHRIs could really help to advance state accountability by submitting suggestions for recommendations to the UN Human Rights Office in the processes leading up to the UPR. And that way, this is compiled, and states who are looking for inspirations and recommendations to make can draw on this. The second mechanism is the treaty body system. There are 9 core human rights treaties, and each one of them has created a monitoring body of experts. It's a quasi-judicial body that assesses the extent to which states that have ratified the treaty are making progress. They hold periodic dialogues with state representatives, and they adopt concluding observations. The main treaty protecting the rights of migrants is the Convention on the Rights of Migrant Workers and Members of Their Families. Now, of the 9 core international human rights treaties, this is also the only one that EU member states have yet to sign up to. However, many countries of origin of migrants are parties to this treaty. So, to the extent to which EU member states or Frontex, for example, engage in cooperation, whether it's on forced expulsions, training, or providing material support with countries like Nigeria or Albania that have ratified the Migrant Workers Convention, they may not undermine the ability of these countries to meet their legal obligations under this convention. And you may have seen that 2 weeks ago, the Migrant Workers Committee, which monitors the implementation of this treaty, of this convention, urged the Moroccan and Spanish governments to conduct prompt, thorough, independent, impartial, and transparent investigations into the deaths of at least 23 migrants who tried to cross the border from Morocco into Melilla, and the committee has called for access to justice for the victims and their families. Now, as I said, many states are not a party to the Convention on Migrant Workers, but still they can be held to account for human rights violations against migrants and refugees under other human rights treaties. For example, the Human Rights Committee, the Committee Against Torture, and the Committee on the Rights of the Child, they have all adopted very clear positions against immigration detention. And countries that have ratified the optional protocol to the Torture Convention are also required to set up a national mechanism for torture prevention, an NPM. We heard reference to it already. And these mechanisms are empowered to pay impromptu visits to all places of deprivation of liberty, and that includes detention centers for migrants. Both Belgium and Ireland still have to ratify this instrument, which would allow for greater scrutiny of detention practices. The third type of mechanism that I want to mention today are the independent experts appointed by the Human Rights Council that are called special procedures. Through their urgent appeals and their country visits, they can raise problems directly with national authorities. And some of you may have seen the press conference of the UN Special Rapporteur on Human Rights Defenders, who just visited Greece, where she criticized smear campaigns against migrant rights defenders, the discriminatory NGO registry, verbal attacks by high-ranking politicians against human rights defenders, and the fact that acts of solidarity are even being prosecuted as criminal activity, all of which contributes, of course, to a climate of fear. In 2020, the Special Rapporteur on Migrant Rights entered into a dialogue with the government of Croatia on compliance with the principle of non-refoulement, the prohibition of arbitrary and collective expulsions, and the right to seek international protection. And I'm just giving these few examples, but in fact, any individual can file a complaint with the special procedures. And they very often write letters asking the states to provide explanations. The Special Rapporteur on Migrants, by the way, is planning a mission to the Polish-Belarusian border this month. And we will share in the chat box the report from his report from last month on trans prevention and accountability at international borders. Now, our office, the UN Human Rights Office, we have a very difficult acronym, OHCHR. We have published a trainer's guide on human rights at international borders to support states and in particular border officials. And as a member of the Consultative Forum on Fundamental Rights to Frontex, we have undertaken a project to raise awareness at Frontex about the UPR recommendations that are accepted by EU member states. And of course, also with a view to strengthening the Consultative Forum in its advisory role. We've also been advocating for improved and comprehensive monitoring at EU borders, which is critical to establishing accountability. Now, as we all know, the EU screening regulation of the EU Pact proposes the establishment of independent national monitoring mechanisms. And in the lead up to this proposal, we brought together experts from international and regional monitoring mechanisms who, based on their own monitoring experience, shared advice with the European Commission. And we've also contributed to the guidance of the EU Fundamental Rights Agency on the matter. But let's not forget that monitoring is not a goal in itself, but a means to advance accountability and improve respect for human rights. We therefore very much welcome this webinar to exchange concretely on how we can bridge the gap between monitoring and accountability, because I profoundly agree with both previous speakers who said that this is fundamentally a rule of law challenge. And we must join forces so that human rights standards are effectively enforced, people can meaningfully shape migration policies and challenge policies that undermine human rights, and perpetrators of human rights violations must be held to account. And thank you very much, and wishing you a very fruitful discussion.
Thank you very much, Birgit, for this overview of some of the UN mechanisms and processes that are in place and that can contribute to accountability, but also for your strong support to NHRIs in Europe and other human rights defenders as well. I will now turn to our next speaker from the European Commission Unit on Schengen and External Borders. You may have realized that we were initially expecting Corinna Ulrich, but she couldn't be able to join us today, but we're very pleased that Maurice Mote, who also works for the unit, is here and can speak about the European Commission's perspective on the topic. And it will come as no surprise to the participants that the European Commission could play an important role or should play an important role in ensuring human rights accountability at borders. We really appreciate you being here, and I'll give you the floor now, Maurice, for 8 minutes. Thank you so much.
Thanks very much. Thanks for having me, and apologies on behalf of Corinna that she couldn't make it today. So for this last minute change, thank you as well for the excellent report. For me, it's an honor to be here with you, with the honored guest, to have this opportunity to speak to you all, and to be recognized, or for the Commission to be recognized for our role in ensuring that our external borders are protected and ensuring that that protection is realized within the framework of our system of values. So human rights, or what in the treaties are referred to as fundamental rights, are for us non-negotiable. That's the Commission's position. That's our starting point on any examination of fundamental rights related issues. If you look at the Schengen Borders Code, the first substantive obligation is the obligation to respect the fundamental rights framework. It's Article 4. It mandates that member states, when applying the code, act in full compliance with human rights legislation, including the Charter and the Geneva Convention. So border controls are intended to combat illegal immigration, to trafficking, to prevent threats to member states' internal security, public policy, etc. Member states are required by the Schengen Borders Code to introduce effective, proportionate, and dissuasive penalties for the unauthorized crossing of external borders. But again, these actions must be carried out in full respect of fundamental rights and the asylum acquis. So we go back to that bottom line. When you look at the European Border and Coast Guard, whether it's staff of national authorities or staff of Frontex, they must perform their duties in compliance with these obligations. Border guards must fully respect human dignity and fundamental rights when they perform their duties, and any measures they take to protect our borders must be proportionate and object to the objectives pursued. Any action to the contrary is illegal. That's our framework. The Schengen evaluation system, which was mentioned earlier, puts a lot of emphasis on ensuring that border guards are well trained in this regard and that the instructions that they are given are clear, specific, and understood, so that border guards, when they're doing their duties, know what they're supposed to be doing. It's, I think, for me, a rather straightforward legal framework that we can start with. But then we come to the role of the Commission. And depending on your position, unfortunately or not, the Commission's powers are not limitless. We, particularly my unit, are inundated with letters from concerned citizens every time that there's a report of death or abuse along our external borders. We get letters asking how we can tolerate such tragedy, why we're not doing more to prevent it, accusing us of complicity in some cases. And I understand that. I mean, mistreating those who have already lost everything, who are coming to us in the hope of finding peace and a better life, is never excusable. The stories, the pictures of men, women, children, being tripped, being beaten, washing up drowned on our beaches or disappearing forever in the Mediterranean tears at my heart, just as it does anybody else. I mean, this is, I think, just a human reaction to these things. But like I said, any such action and any causing of such pain is already illegal. It's a violation of the Schengen Borders Code. It's a violation of the European Border and Coast Guard regulation. It violates the treaties. It violates the charter. It violates the national laws of every member state. And as the Commission, we expect member states to follow up on these allegations. We expect prompt, credible, thorough investigations, establishment of facts, and the sanction of wrongdoing. But it's not a role that the Commission can assume. We don't have a criminal investigation branch. There is no EU FBI. We don't have the competences and not the resources to investigate individual breaches. That is something that authorities of the member states need to do themselves. Where the Commission can potentially play a role is when we have a systemic issue, a structural deficiency, where the issue is not individual bad apples or individual actions, but rather where a member state has strayed from the legal obligations. And here, for instance, we could launch infringement proceedings. But the threshold for determining allegations of misconduct at an individual levels are actually systemic misconduct are high, and such legal proceedings do take years. And the evidentiary challenges that we would face are significant again, because you have shocking videos, you have reports of individual mistreatment, but how you get from those individual reports, individual pictures, to being able to argue that there's a systemic issue is rather difficult. And the chances of success in court are, in my opinion, rather small. And so what we're pursuing, or what we are encouraging, is the development of trustworthy, unbiased, and effective monitoring mechanisms. This is the logic, for instance, behind Frontex fundamental rights monitors. Under the EBCG regulation, every Frontex operation has a fundamental rights monitor attached to it, and his sole task, or her sole task, is to constantly assess the fundamental rights compliance of that operation. This means that any border guard in that operation can rest assured that if their actions are not in compliance with our laws, there's somebody there that will make them aware of that. If they have questions, there's somebody there that they can ask. It also ensures that anybody whose rights are violated will have, in the context of such an operation, has access to a credible, effective complaint mechanism. So in the Migration Asylum Pact, we've also proposed a screening regulation that calls for an independent monitoring mechanism of screening activities. We call for independent observers that are able to report impartially, neutrally on the actions of member states at the borders. This way, member states can identify shortcomings and protect authorities from perhaps unjustified criticism, while also ensuring respect for migrants' rights. However, the only way for such a mechanism to work is if all parties, particularly government and civil society, trust the observers and the reports they produce. So honest, open reporting is a win for national authorities, who should be proud of the work that their people do, for civil society, who's concerned about maybe abuses being concealed, and most importantly for the migrants themselves, whose fundamental rights should never be threatened on European soil in the first place. And the monitoring mechanism is still under negotiation, but of course there's nothing that would prevent member states from establishing independent monitoring mechanisms already now at the national level. And the Commission expressly encourages member states to do that. And I think this is where we can come to the importance, the criticality of national human rights institutions. You are in a unique position through your role and your status, your expertise, your experience, your networks, your resources, and your mandates, that you can bridge the many gaps that we have here that can lead to maybe insufficient accountability at the borders. NHRIs can establish complaints mechanisms that are clear and accessible and credible to all parties. NHRIs can maybe support or conduct independent investigations into allegations of wrongdoing. You can provide expertise and counseling. You can advise lawmakers on ensuring that legislative proposals are consistent with EU standards, and you can educate border management authorities. As such, I see the role maybe of NHRIs as a crucial element of the Commission's ability to strengthen human rights accountability at the border. The Commission, the union agencies, the national institutions have strengths that need to coordinate, and together I think we can significantly improve our ability to ensure strong protected external borders where the rights of everyone who seeks to enter are unquestioningly respected. So that would be my position, or the views from my side. Thank you very much for having me, and I look forward to discussing.
Thank you, Maurice, very much. It's very clear on what the European Commission is doing and can do. And in fact, NHRI has put forward recommendations or suggestions about how we can further strengthen that cooperation. For instance, how the information monitoring and recommendations of NHRIs can inform the identification of those systemic issues or deficiencies that you mentioned, but also how the European Commission can speak up when NHRIs face issues, for instance, when they work on migration or questions of funding and resources, for instance. So there is clearly an important role and scope for further cooperation there. I'll now turn to another EU institution. So the European Parliament has been a key actor in calling for accountability, both at the national level, but also when we talk about Frontex. We're delighted that the member of the European Parliament, Tineke Strik, member of the group of the Greens and the European Free Alliance, can be here with us. Tineke, you've been one of the most active and outspoken MEPs working on migration and human rights. So I look forward to hearing your views on that topic, and I'll immediately give you the floor. Thank you so much.
Thanks a lot, first of all, for the great report that you have presented. It's very comprehensive with a lot of also concrete recommendations. You touch upon all aspects, I think, of about accountability, and many different actors can really benefit from these. And thanks a lot for being in this rich panel. It's really an honor for me. So. Yes, accountability. It's true that what Maurice just said, the member states have the first responsibility to make sure that they act in compliance with the fundamental rights. But what we see so far is during the last years that the impunity that they enjoy also from the EU side has had a lot of consequences already. I think it has led to more openness and systematic pushbacks. It also has had a spreading result that more and more member states are conducting pushbacks. It leads to more repression to the national actors which are critical, such as NGOs and journalists, because they are then the only one messaging about the wrongful conduct, and they are repressed, also not followed by a strong message from the EU side. And it may also lead to less willingness or courage of judges to act against it by, for instance, declaring it as a violation, or by referring questions to the CJEU, as there is such a silence at the EU level if it comes to these violations. So actually, I find it very encouraging to hear from Poland that there are still Polish judges speaking up and not accepting these violations to take place. And I think it also has contributed to the shift that we see in the debate. It's not only anymore about if there's sufficient evidence about pushbacks, it's more the question of, well, why shouldn't be allowed to violate the rules, or is it really a violation of the rules? We see it more and more that the whole legal framework is being disputed, like saying that the concept of preventing departure is not very clear, that it's not clear what the rules are in maritime law. And of course, we also see the call from member states to the Commission to fund also fences and technologies at the border. So this dominant debate gives a lot of room for states to present pushbacks as accepted, or at least as a kind of collateral damage in the need to guard the borders. And this increasing security focus, especially I think since the Belarus crisis, fuels also this notion of irregular migration as a security threat, which allows for more repression. And what we also saw very recently, that we saw the CGU judgment on the Lithuanian legislation. The court is very clear that the legislation is violating EU asylum law. And the minister of Lithuania simply says, we're not going to implement this judgment. And what we just heard in the introduction, that Finland is about to adopt legislation also allowing for pushback. I think this all fits in this concept, and it makes so clear why it is important to have a consequent and persistent action in enforcing compliance with the rules that we have. So tackling impunity is vital. And of course, if it comes to incidents, we need to have these investigations at the national level, and we need to have prosecution to take place. But if we see that it's a systematic nature, then it's more of a political choice by governments. It's more policy. So it's not anymore the fact that if you tackle one individual border guard, you have a solution. And then the European Commission comes in. We as a European Parliament, we have a role, a political role in scrutinizing the Commission's role as guardian of the treaty. We cannot legally force the Commission to enforce compliance, but we can keep the pressure, and this is what we do. Last week, I presented a study. Happily, also your colleague Maurice was there, in which the arguments of the Commission are challenged. We have looked into the argument. What we also just heard, that the Commission is not an investigative body, and therefore it does not have sufficient legal grounds to make a successful case for the court. In this study, and I will share it, my colleague will share it in the chat, we have given an overview of the case law of the European Court of Human Rights and the Court of Justice, where they also use a number of authoritative reports having consistent findings about violations at the border or within countries, which they use and find sufficient ground to say that these violations take place, or at least that it's now the turn for the member state itself to come with counter evidence. So the reports that are out there shift the burden of proof to the member states. And if they cannot fulfill that, the courts presume that these violations take place. So this also gives the possibility for the Commission to, on the basis of all those UN reports, Council of Europe reports, Ombudsman reports, to really start infringement procedures or other actions. And we urge the Commission to do so. And specifically, of course, if national legislation is allowing for pushbacks, because then you don't have this evidentiary higher threshold. It's very clear then that there is a violation. And the study also emphasizes that the financial instruments, the regulations covering the fundings, give sufficient ground to condition border management funding to respect for fundamental rights. And that should and could be used more, I think, by the Commission. Right now, there is this review process of all the national applications for integrated border management funding. And I really hope that the Commission can show to all of us actually how they are using these reports to make sure that they have guarantees on respect for fundamental rights. We saw that the Commission did so regarding some emergency funding related to Croatia and Greece. There, the Commission made clear to those countries that they needed to set up a monitor mechanism. But there you see actually also the risk if it doesn't come along with sufficient safeguards, because in both countries, we now have a type of monitor mechanism which really lacks sufficient independency. The transparency body and the Croatian monitor mechanism, and they come out with reports saying nothing is wrong, everything is in compliance with the law. And this actually undermines all the reports that are there that are very thorough and have a lot of evidence on the violations taking place. So either the Commission should act on the basis of these reports already and immediately demand respect for fundamental rights, or they impose the obligation for monitor mechanism, but then it should be, in compliance with a lot of criteria so that we are sure that, that this monitor mechanism report was really going on. I would say also, if it comes to monitor mechanism, use the monitoring bodies that already exist, like ombudsman, national human rights institutes, NPMs, etc. We filed a request for funding a pilot so that a pool of these monitoring bodies can work together and support each other in the different member states. Now I come to legislation. Sorry, I only have 30 seconds left. The screening. It's still indeed under negotiation in the parliament. What we try to do is enlarge the scope, because now it's not clearly already covering the green zone. So what is really happening at the border? It's only covering the screening procedure as such. And there we try to strengthen the safeguards, like a strong, clear criteria on independency, on resources, on mandate, and also on the independent complaints mechanism that should be ensured. The Schengen Border Code is very worrisome. The definition of instrumentalization is very broad. And in the case of instrumentalization, there can be less border crossing points, which are less accessible, more surveillance, more focus on preventing departure. So we really try to push back a little bit and make sure that there are sufficient safeguards, because also in instrumentalization cases, we need to have safeguards to have access to an asylum procedure. Also, the Schengen Border Code allows for pushbacks at internal borders, so immediate transfer back to the member state where a person comes from. And this, I think, it not only violates fundamental rights, but also the Dublin system, where you have at least the possibility to rebut the idea that you could be sent back to the first member state you come from. Also, the instrumentalization regulation is under negotiation, which actually leads to less safeguards in the whole asylum system, less safeguards for the asylum procedure, for the return procedure, and also more detention possibilities. And this is also clearly overlapping the proposal for the crisis regulation, where in the crisis regulation, there are at least safeguards for relocation and for immediate protection. And this is all not there in this instrumentalization regulation. Now, the Schengen evaluation and monitor mechanism is revised. And I think we should make use of that because it now includes fundamental rights and the obligation to involve monitoring bodies. So really make use of that. I would also say that all actors should anticipate on this mechanism, make sure that their information is being provided and shared with the supervisory mechanism. And also, we also heard about Maurice saying that they already get a lot of letters, but I think we still should increase the number of complaints at the Commission, showing what's going on so that they can act upon it. Sorry, I didn't come to Frontex, but maybe in the Q&A I can say something about that. Thank you.
Thank you so much, Tineke, for your commitment, but for also showing how new EU legislation policy can widen these gaps, but also showing what could be done at the level of the EU to help us bridging those gaps in human rights accountability. With that, I just have to thank our panel so much for your interventions. It's been really rich, a lot of information there. And as a reminder to the participants, you will be able to ask questions, but just not now. First, we want to hear also from the perspective of civil society organizations, lawyers, but also the importance of the meaningful participation of migrants and refugees when we talk about human rights accountability at borders. So if you have questions, you can already put them in the chat or just hold them for a bit. And now we are gonna take, I would propose a 2 minutes break, so just a comfort break, and we'll be back at 11:07. And yeah, so thank you very much, and I'll see you in a bit. Don't leave us. Thank you. Thank you very much. I hope, despite being very short, that you enjoyed the break. And I think we're good to start again. I'll ask my colleague to also spotlight the speakers for the next panel before I can present them. Perfect. Thank you so much. Yeah, so let's continue our conversation. I think we already heard a lot, but there's more to be said for sure. So we cannot talk about human rights accountability without recognizing the key role of NGOs and civil society organizations. So they have been monitoring human rights abuse, contributing to access to justice, and also liaising with migrants on the ground. And one of these organizations is a border violence monitoring network, which has been providing essential information on what's happening at Europe's borders. So I'm delighted to give the floor to Milena Zajovic. The floor is yours, and you have 8 minutes. Thank you so much.
Thank you very much. That was a good pronunciation of my surname. So to those who don't know me yet, my name is Milena, and I am here on behalf of the Border Violence Monitoring Network, which is a coalition of 15 NGOs and collectives dedicated to monitoring and reporting on human rights violations at the so-called Balkan route. We are covering the area from Turkey to Austria. And 5 years ago, our network developed a common framework for recording testimonies and also supporting evidence, which are fact-checked and published in an open source database that is available online. And the testimonies of the victims are also collected in the Black Book of Pushbacks, which is a 1,500 thick archive of printed evidence. According to my knowledge, I think this is the biggest source of data on pushbacks until this date. If you look into these resources, you will learn that only our small teams of volunteers managed to collect testimonies of pushbacks affecting nearly 25,000 people, all the way along the Balkan route. Our case reports include hard facts such as geolocations, demographics of victims, pictures of the injuries, when applicable medical documents, as well as detailed descriptions of the incidents. Those include analysis that provides deeper insight in trends such as disproportionate use of violence that affects 85% of victims at the borders of 11 countries along the route. It allows us to understand that, for example, 52% of pushback groups subjected to torture or other forms of inhumane treatment by Greek authorities contained children and minors, or that children were present in 54% of cases involving gun violence at Croatian borders. Many people say it's absolutely amazing we managed to collect this data, but I think that the burden of proof shouldn't be on the small grassroots organizations. This should be a parallel effort of civil society, human rights institutions, and the national judiciary. However, public attorneys in key countries such as Croatia, where I'm from, or Greece or Hungary, don't seem to be very willing to investigate cases of pushbacks. And even when they're presented with more than enough evidence, it always seems that some component is missing. And even if we manage to reach the courts, for example, in countries such as in Croatia, the cases are dismissed in a way that raises serious concerns about the rule of law in Europe today. Precisely due to these institutional gaps, many of us were calling for establishment of a more formal independent monitoring mechanisms, as also mentioned by several speakers today, and as foreseen in the new pact. First such mechanism was established a year ago in Croatia. Unfortunately, it was set up by the very same authorities whose conduct it was supposed to investigate. So it is no wonder that the implementers said they found no violations at Croatian borders. Actually, in the first interim report published by this mechanism, they actually did recognize the existence of pushbacks, but this report was very quickly deleted from internet and replaced by the final version of the report that said no violations are happening. All mention of pushbacks was just deleted. In Greece, the work of the National Transparency Authority, who is acting in the capacity of such independent monitoring mechanism, seems to be equally unproductive. And as Tina already mentioned, I must say the real harm of these very much state-controlled mechanisms will not be finding no evidence. It will be using their non-findings to annul years of work of organizations such as ours by saying if the official mechanism found nothing, it means no violations are happening. At the same time, truly independent monitoring of abuse at the border areas is becoming increasingly difficult, especially for the NGOs who try to ensure access to asylum for victims of pushbacks. For example, you might be aware of the announced investigation of the Greek authorities who are now scrutinizing NGOs, including potentially our members, who have been engaging with the European Court of Human Rights to ensure interim measures are being issued for groups of people that were stranded in the Evros Islands. And instead of investigating how and why these people were left stranded there for days, the authorities are now investigating human rights defenders who warned them about the issue. And this MO of investigating and even prosecuting people who are engaging with ECHR or other institutions to ensure fundamental rights of victims are being respected started in Croatia, where two of our activists of the NGO Are You Serious, which I lead, were directly targeted, and one of them even convinced in the court after supporting the case of a 6-year-old girl who died during the pushback. And in the verdict, European Court of Human Rights actually clearly said that our activists and lawyers were targeted in attempt to prevent this case from reaching Strasbourg. At the moment, out of 15 now members of our network, at least 8 NGOs experience criminalization or other forms of institutional attempts to silence our advocacy teams and to stop our monitoring activities. And I feel this is a very dramatic information that should be taken seriously by institutions who could and should provide more support to targeted human rights defenders. We also hope for more proactivity of the national human rights institutions in investigating pushbacks and other forms of violations, because frankly, it is very discouraging to read that many ombudsperson's offices in key countries such as Greece are also saying no violations cannot be proven. I'm aware of the limitations of the institutions such as ombudsperson's offices when it comes to the scope of their mandate, especially if they were to engage in the cross-border investigation, which many of them cannot. But we are hoping to see more proactive engagement in overcoming these obstacles. One of the valid attempts was the feasibility study recently presented by Markus Jäger and collaborators such as Laura Vidovic here, who proposed the alternative monitoring mechanism led by NHRIs. And I feel if they would be a stronger investigative project led by national human rights institutions, open to inputs from civil society and responsive to distress calls of victims, this might be one of the avenues to pursue in hopes of ensuring real accountability at European borders. And just to conclude, I'm completely aware that I'm not saying anything revolutionary when I say that NGOs, human rights institutions, and MAPs, for example, should work together in pressuring the Commission and pressuring judiciary to do their job. But the fact that we have to stress this says that there is a lot of room for improvement here. And we are, of course, very happy to work in ensuring this improvement happens. Thank you very much.
Thank you, Milena, so much. And you have highlighted how so well the gap between what we already know and then the unfortunate fact that nothing happens despite the efforts of different actors. And you explained that so well. I will now turn to our next speaker, and we'll look into the important role of lawyers as well in ensuring access to justice and legal remedies when violations occur. So we have with us Nikola Kovacevic, hopefully also good pronunciation, who is a human rights lawyer in Serbia, also winner of the UNHCR Regional Nansen Refugee Award, and a member of the European Committee for the Prevention of Torture. So Nikola, the floor is yours. Thank you so much for being here with us.
Thank you, Gabriel. Thank you for having me. And I also want to congratulate you on a wonderful report, which contains very useful guidelines and recommendations on how to overcome the systemic problem of impunity that we are facing at the European borders. And what I plan to talk about today, because many important things have already been mentioned, but I would like to focus on the role of civil society organizations and to add a couple of things which Milena has already outlined perfectly clear. And the work of the Border Violence Monitoring Network and many other NGOs is a light in the darkness in which we live in the European continent, which is becoming a fortress of Europe, not a place where the Refugee Convention, the European Convention on Human Rights, the UN treaty system is being respected. So when it comes to the accountability, I always like to say that there are two layers. The first one is accountability of individuals who are performing the acts of ill treatment, of arbitrary deprivation of liberty, of denial of access to asylum, denial of access to territory, who commit acts of expulsions, formal or informal, legal or illegal, depending on the legal framework, but without the assessment of the risks of refoulement, where they do not assess the individual circumstances of refugees, asylum seekers, and migrants, but also the accountability of the states. So these are the two layers which I believe are very important. And in order to achieve the first one, it is impossible to do it, in my personal opinion, if you don't have the state on board. And as we all know, we have the situation in which not only policies and practices are being designed with an aim to deter people from accessing their rights in the border areas, but the laws are now starting to be changed. Not only the regular legal framework, but we have witnessed in the past couple of months or in the past year or two. Let's go back to Greece in March 2000. 2020, before the COVID started, there was a state of emergency, and there was a legal framework which basically disallowed people to access territory and asylum procedures. So when we talk about this kind of legal frameworks, we see that the countries have slowly started to resort to amendments of the legal framework in the emergency circumstances, which are derogating from something which cannot be derogated. Or if we go to a situation in Hungary, where the state has tried to legalize pushbacks, or to allow state authorities to intercept, apprehend, and expel back to Serbia any foreigner who was found initially it was in the first 8 kilometers after the border crossing. Now this rule applies in the entire territory. So we live in the times when states are are being willing to go so far to legalize something which cannot be legalized, or to legalize something which is so much contradicting the international human rights law framework, the international refugee law framework, that I believe that this individual accountability cannot be maintained in these kind of circumstances. So another layer of accountability for which I believe we have left as a civil society, as individual lawyers, is to try to bring cases to international forums and international bodies. Yes, European Commission is important. I believe that also various different bodies which can produce reports, recommendations, which can put political influence on the states is important. But what I believe we are lacking as a civil society, and not only because it's our fault, but because the resources which the countries are using are tremendous. So you are faced with the machinery, billions of euros, modern technology, barbed wire fence, Frontex, a lot of layers of protection. And on the other side, you have a group of enthusiasts who are trying to face the situation that, you have trained military personnel, you have trained police officers, you have thermovision cameras. And in these kind of circumstances, with the people on the move, because all of the countries that we have mentioned right now are the countries in which people are not willing to stay. So in order to bring the case before the Strasbourg Court, before the Committee Against Torture, the Human Rights Committee, or any other international body, you need to, in this kind of circumstances, find the client and find the case which now meets the very harsh criteria. For example, establishing the case MD and NT versus Spain, or the recent case against North Macedonia, where AA and others versus North Macedonia, to build the argumentation, to build the relationship of trust, and to wait for 5, 6, or 7 years to stay in touch with that person who will be in Germany, Sweden, or somewhere else, in order to make a landmark victory, as it was the case with Madina Hosseini in Croatia, or it was the case with Ilyas and Ahmed against Hungary, or it was the case with many other cases which are increasing. But like when you compare the number of legal victories achieved in front of the international bodies on one side and the number of pushbacks which happen on a daily basis on the other side, you will see an enormous discrepancy. So what I believe is the role of civil society and independent lawyers who are willing to get involved into this kind of issue is to be perfectly trained and well familiarized with the current situation when it comes to the standards and the practice of the international bodies for the protection of human rights. It is also important to further increase networking, because now nobody can alone deal with more than 1 or 2 cases per year, and to design the strategies which would lead to a mass production of applications before the international bodies. Because if the country commits 100 pushbacks per day, then I believe that, NGO society, independent lawyers can get to the point where 1 or 2 cases per month can be produced, and the cases which are very well selected and which can have a systemic impact. Because I believe that at this particular point of time, we cannot expect the states to change their behavior, because we have seen that, okay, a lot of pressure has been put on Hungary through the infringement procedures. A lot of things European Commission has wrote in the progress reports of Serbia, many other countries. But what we are witnessing right now, and which is it was very well said by the Polish ombudsman, that on one side you have Ukrainians who are welcomed in solidarity, who are provided with as much, with a lot of things which they deserve and to which they're entitled to because of their rights as refugees from the Refugee Convention. But on the other side, on this same border between Poland and Belarus, you have units of Polish border guards who are chasing people from Iraq, from Syria, or from some other countries and sending them back to a country which is not a Council of Europe member state, which is a country which is right now in war, which is under the sanctions, and where definitely their rights not only as refugees, but also migrants who have vulnerable segments of their story, cannot be met. So we have a very obvious and flagrant difference in behavior towards refugees coming from Europe and refugees coming from the other parts of the world. So I believe in these circumstances, what we should do, and I would very much love to, with the help of the independent national human rights institutions, such as the Ombudsman, such as the MPN, to get more involved and to add the component of a massive strategic litigation, of the massive litigation, not only reporting and advocacy, but also litigation, because I believe if we bring enough cases to the Strasbourg Court, to the Court of Justice of the European Union, to the UN treaty bodies, I firmly believe that the situation can significantly change, and that some things which have been introduced in the legal frameworks, which were even derogated from, can be overcome. And then from that part, when we have the countries being responsible and does not want to, let's say, feel this pressure anymore, then we can go down and take care of the heads of the border police departments, the border police officers, or the individuals who are acting as accomplices in undermining the basic human rights of people on the move at international borders. So I just put a link to one of the publications which I worked on with dear colleagues from the Center for Peace Studies. It's a publication which, for example, provides, let's say, guidelines on how to document, report, but also litigate cases on Serbo-Croatian border, because this is where I operate, because I also believe that every border is a story for itself. It has a different context, it has different trends, it has different patterns of behavior of border police. And I believe that, maybe it can be useful for some of the participants to have a look at this and to see how hard it is to collect facts which are good enough so you can take them to the international forum. Sometimes it's more complicated to collect the facts in this kind of situation than to, publish a report. So thank you for having me here, and I'm very much looking forward to a Q&A part, and I apologize for taking more time than I was awarded to.
Thank you so much for not only showing the importance of access to justice and to legal assistance in the individual cases, but looking at the broader picture. So that was very clear message. Thank you. Last but not least, I'm delighted to give the floor to Razan Ismail, who is a refugee activist and individual member of the expert group on the views of migrants in the field of asylum, migration, and integration of the European Commissioner. Most importantly, Razan works for the meaningful participation and representation of migrants and refugees in decision and policy-making processes, also with a strong and necessary focus on gender equality. Razan, I'll give you the floor, and you have 8 minutes. Thank you.
Thank you so much, Gabrielle. Thank you so much, everyone, for your introductions. That was extremely to the point and very painful to hear, to be honest. I would at this moment take just a second to call attention to the massacre of Melilla that happened on the Spanish-Moroccan borders. It happened not so long ago. This is perhaps a prime example of why all of us being here is very, very important. And I'd love to remind everyone that this has happened under the most socialist government that Spain can have. So this is the best case scenario that we're gonna see probably in the near future. And obviously, Nicola mentioned, that the states need to be. Everyone mentioned that the states need to be responsible. I think Teneke said that it can be a political decision. I think in this case, it has been a political decision. It's been weaponized, especially being a reception country, obviously, such as Greece. Such as Poland and the Belarusian, etc. So it has been politicized. It's been highly weaponized. It has been highly politicized here in Spain, and the attitudes of the governments are going more and more extreme, especially that the migrant and refugee collectives here are not able to vote. So their narratives, basically, and opinions don't matter, and this is why we are working on meaningful participation in policy and decision making. So obviously, access for NGOs need to happen on the ground in the frontier. But when the possibility of exporting not only a political decision to not only export the frontier, but also export the murders and export the culpability, that's when maybe we need to go by a different route, or maybe us working together from all the different directions needs to happen. For example, in the recommendations, there was revisions of practices, policies, and legislations, and creating a culture of human rights. I think these are super long-term, super difficult recommendations to implement. And obviously, without working on all the actionable, immediate sides of the recommendations, or the work of every other colleague who have spoken here today, it won't be possible, but it needs to happen at one point. So involving migrants or refugees in these revisions, in the creation of the culture of human rights, that needs to happen. And up until now, we in Human Connectors, and me personally as well, working on meaningful participation. And that means that, the participation mechanisms that we've had so far are not enough. They are borderline tokenistic. And what we're looking for is actually transformative participation. Even on the level of the massive organizations or the small organizations that work on the borders, also we need to understand meaningful participation. Is it really happening? We know that a lot of organizations are actually working for or doing for, but also the doing with is also extremely, extremely important. So I just invite everyone to kind of reflect on everything that they're doing, whether it's in a very simplified way, whether it's doing to the migrants or refugees or asylum seekers, doing it for them, or doing it with them. And when we reach that level of doing it with them, where we share the decision making, where we share the initiative taking, and then we share the decisions and make the decisions together, that's when any participation starts to be meaningful, to have a meaningful impact. And even in the best intentions, and where decision making starts is actually in the research, right? In the research and the collection of information. Any policy interventions starts there, but unfortunately we're stuck at the consultation level at the moment. So, for example, in the expert group, I'm a part of the expert group on migration with the European Commission, and to be honest, we're stuck at a consultation level, and it's very little impact. It has little impact because we're consulting on things that have already, on policies that have already been designed, that have already been decided. And they say, oh, do you like this or not? And then they try to include our feedback and our lived experiences, because all of us are migrants. Thankfully, this is the first time that this happens, FYI. And they try to kind of squeeze it in, if it's possible, within the already stated framework. And this is hardly meaningful. So because there's reluctance to change in the power relations and the spaces that are created, the consultations are not enough. We need to go deeper, we need to go further. So even in the knowledge production processes that are involved in the decision making, obviously, in any decision making process starts with the knowledge production. It needs to take into consideration the lived experiences of the people who went through that journey or are there in that journey. Because you say reality is subjective, but this is their reality. And if you say, or if we say that they have a right in the hallways of Brussels, doesn't mean that they have access to that right. And we need to take their experiences, their challenges into account. We need to have a massive shift as well. Maybe it would be welcome to have a shift towards narratives as well, because that hopefully will change attitudes on a political level. Like I said, for example, prime example is in Spain. It has been highly politicized and highly weaponized, and especially that migrants and refugees cannot vote. They're not taken into consideration, and very, very harmful narratives have been created and cultivated through years and years of narrative creation, and that needs to also happen even on the frontier level. And again, and this is why we're here, I guess, is even after the consultation, there are still major problems with the follow-up mechanisms of any consultation problem, any recommendations that we're doing. There are problems with follow-up and accountability. So that also needs to be addressed by policymakers. So, I mean, how meaningful participation should look like? We need to have refugees and forced migrants to have access to all levels of decision making on a national, on a European level. There needs to be better level of refugee representation, moving away from tokenization, where we hear the same stories and the same people over and over and over again. We need to have real representation within these levels. And I also call for even the organizations, again, that work in the field of either forced displacement or human rights on the frontiers, to take a little bit of a, of a reflection on the diversity of their staffing. And the programs, does it guarantee representation of the people who have been through that experience who are there? And also in the production of knowledge, because the lived experience is a reality that we cannot ignore. And that's it for me. Thank you so much for having me, and looking forward to the Q&A.
Thank you very much. It's very clear on the importance of ensuring active participation and meaningful contribution of refugees, migrants, people with lived experience. And that's also a message that should resonate as well with, as you mentioned, other civil society organizations, national human rights institutions, and across different levels from the national to the regional. So that was very clear. Thank you so much. Well, with all this rich information in mind, I think we can now move to our moderated discussion and questions and answers. And for that, I'll leave you in the excellent hands of Laura Vidovic, who is now independent human rights consultant, but many of you will know her as the former Croatian ombudswoman, also previous chair and board member of NHRI. We're delighted that you can be here with us, and I'll pass you the floor. Thank you so much.
Thank you, Gabriel. Please, could you first confirm that you can hear me well, because I'm a bit worried that my sound doesn't work. Thank you so much for your kind words, and good day to all of the colleagues. I'm really thrilled to continue to work on this important topic and together with NHRIs and NHRI, because I am a first-hand witness to the continuous and high-quality work that you all do when it comes to human rights of migrants at the border. So thank you so much for inviting me to participate in this webinar today. So without any further ado, and not to take too much time from the discussion and Q&A, I think we are all very much not only informed, but also inspired by the previous panelists that we heard today. And before I open the floor to the discussion and to the Q&A, I just, as a matter of housekeeping rules, would like to remind everyone that we should keep the interventions to the topic, which is accountability at the borders, and also to be mindful of the time, because we have only a bit of half an hour left. Also, I am aware that Tineke will have to leave shortly, so if anyone has any questions for her, please indicate that. You can either raise your hand or sign up in the chat, and we'll try to keep up with your interests. So who would like to start first? I'm sure many of our participants are so much involved in the topic, either working for the NHRIs or working for our partners in European Union or UN or in the civil society. And I must say, I was taking notes throughout the interventions, and there were some really interesting points that were raised. I must say, one I found very interesting, and I'm not so sure if it is innovative, but what Nicola said about massive production of cases to the courts to be able to achieve some progress that way, all the way up to the European Court, is something that's I find it very interesting. I think there were also some other points of consensus, which is like, for example, changing the legal framework in the direction of the securitization, not only of border, but the society in general, which is, again, another very strong regression when it comes to the standards of human rights that we hoped, we believed we achieved, and is now taking the step worse. And I think that's something that we have to be mindful of and discuss it again and again. Perhaps also, if there are no direct questions to start with from the participants, maybe the panelists would also like to add a few more comments. Tineke, because I know you have to leave, you wanted to add something about Frontex as well. Please.
Yes, so that's a sort of abuse of my the lack of speaking time I had before, but I think it's, I mean, there's a lot going on, of course, with Frontex now. Finally, as a result of the many reports that we saw, including the report of the European Ombudsman, of course, on the lack of effective and independent complaint mechanisms. And we also had presented a report with a lot of recommendations. And I think actually that the OLAF report has created actually the most important momentum. It has, it had made it undeniable anymore that something needs to be done. And I think that the shift in the management now, and also the more awareness also of the management board that they are having a responsibility that they should take, hopefully really leads not only to more effective procedures, but also to really a change of culture, which also the report of the NHRI also emphasizes how much that is needed. It also means, I mean, the interim director, she also expresses that it's for her very important to be more transparent. And I really hope that also from the European Parliament really seizes this opportunity by really forcing changes that we have to see now. We are now currently also looking at the budget approval for Frontex, where OLAF plays a role again. Because many MEPs, we are now actually reading the OLAF report, and it's really shocking, many MEPs. So that's also creating a more pressure also in that regard. And if it comes to indeed complaints mechanism and monitoring, I think it's important that we will try to make sure that national monitoring bodies throw fundamental rights monitoring, fundamental rights monitors, that they are going to work closely together, because where Frontex is, there are also member states active. And I think the more fragmentation we have, the more possibility that things do not come through, or that they're, due to different reference procedures, that no effective follow-up action is being taken. So I think that's very important, that all the information comes together, and that there's also kind of collective responsibility for the follow-up. And also that Frontex, that I'm very much pushing for Frontex to be much more demanding to the host member states. So Frontex often says, we have limited possibilities. They can send us away. They can decide not to cooperate. If, on the other hand, Frontex is very hesitant or actually reluctant to use Article 46 to really withdraw its operations. And therefore, I also say, look, you have more in your hands than that you're using now, because this operational plan, it needs to be concluded by both parties. So Frontex can also put more conditions in the beginning in the operational plan to ensure that host member states cooperate. If a serious incident report is being submitted, that they not only deny things, but they really give proper information, and that they give access to all the spots and information for the fundamental rights monitors. So even if they're not going to withdraw completely, at least that they use the different steps, upscaling, in order to push for more compliance. Thank you.
Thank you, Stineke. And yes, Frontex is a topic in itself when it comes to human rights compliance. I'm sure we all share that impression. But thank you for also emphasizing another point that many of our previous panelists touched upon, and which is the importance of systemic, planned, structured, strategic collaboration all of us working together, NGOs, NHRIs, international community, European community, networks, volunteers. So I think that's something that no matter how long we already work together and how much we speak about it, we need to take it a step further. And I guess that is a good takeaway point also from this webinar. There are two hands raised. One is Sanja Salkic from Croatian Ombudswoman's Office. Sanja, you have the floor.
Can you hear me? Can you
Yes,
hear me all?
I can hear you well.
Hello to Laura, hello to everyone. I would first like to thank NRI for the organization of the event, but also for the entire project, for the effort to identify the gaps and to address them. As an NHRI, we participated in the various stages of this project, and I would simply like to stress again certain of our contributions. So first of all, when it comes to the efficiency of the border monitoring, it is very much conditional upon access to all of the relevant data, whether it's paper data or electronic data. And as some of you probably know, we have had the issues with the access to the data of the Ministry of the Interior's information system, and it continues to be the issue still. When it comes to the oversight of police conduct, there are some concrete measures that can be taken, such as improved recording of all border activities. And I'm talking about video recording, thermal vision cameras, GPS locators and such, but also conducting effective independent investigations. Furthermore, it is very important for all relevant stakeholders in charge to continue and to clearly communicate messages of zero tolerance to violence and the respect for the rule of law. And when it comes to our institutions as the national NHRI, we have been and will continue to address the gaps and to identify the gaps by working on the cases, by cooperating, by our reports to the Croatian Parliament, as we have been doing so far. Thank you very much again.
Thank you so much, Sanja, for reminding us all of the important components of the oversight and assuring independent monitoring, such as access to data, which is very often challenging, I'm sure, for many NHRIs. Now, Sirpa, I see your raised hand, but also, can I please just put you on hold for a little while longer, because sure. I see in a chat that there's a question for Tineke, and while she's here, could you please explain a bit more about the pilot project she had mentioned about supporting cooperation between ombuds, NHRIs and other independent bodies? And I guess the other part of the question is for the Commission. So Tineke, please.
Yeah, thank you. Yeah, it was actually a project where many people worked together. A consultant who worked previously for the Council of Europe, Marcus Jager, the Greek ombudsman, some other ombudsmen, and they already did a feasibility study before on the possibility to have a kind of joint monitoring, so have a pool of national bodies also, monitoring in other countries. So supporting each other, actually, also in the hope that they can strengthen their position if they are under pressure in a certain member state. And also have a collective reporting back, of course, to EU institutions. Now, so far, the Commission is a bit hesitant to go into that. So, but we found the application, but they are now considering maybe still to finance something, so to make it work on a smaller scale or a temporary scale, so that we can learn from it. I think it's very important that we get experience with it, practice with it, in order also, if the screening regulation will be adopted, that we can also further continue to have these practices. So it's difficult to be more concrete because it's still in the stage of assessing and seeing how the Commission, because we depend actually on funding by the Commission of this pilot. So maybe the Commission can say something about it.
Thank you, Tineke. I will now pass the floor to Sirpa and then to Commission for the question in the chat, but also perhaps we can add this one about the pilot project and the feasibility study. Sirpa, please, you have the floor.
Thank you, but I would be perfectly happy if the Commission takes the floor first, because Tineke referred to the Commission, and maybe some of the answers are also there that I was about to raise. So if the Commission wants to go first, I would be perfectly fine.
Okay,
sure.
thank you. I'm sure, Maurice, I'm sorry, if you could just also briefly reflect to the question that it's in chat, which is connected to this one.
Right.
Also, how to better ensure independence of monitoring bodies and making better use of existing ones.
So I think at this point, and this is me thinking here off the top of my head, it's difficult, I think, to ensure the independence of monitoring bodies, because these are still bodies that are set up at the national level. These aren't under Commission control. So I think where we can be effective, or where we can help, is by encouraging independence, by perhaps providing guidance, providing training. We have the Fundamental Rights Agency. We have, in Frontex operations, as I mentioned, we have the fundamental rights monitors that provide a good example of how independence works and what the standards are. So I think in that sense, we maybe encourage the independence of the monitoring bodies. And in terms of making better use of the existing bodies, again, it's with Commission support, by underlining the importance of these bodies. Maybe that encourages member states to rely on them. And we mentioned a lot earlier of reports coming in from NGOs and things like this. And I think Ms. Strick remembers in the FRALO working group, reports from NGOs were often not ignored, but kind of dismissed by member states as maybe not being sufficiently independent. So here, where we have bodies such as the NHRIs, we can again underline from the Commission's perspective that these are valid contributions, that these are independent, effective monitors, and that our support is there, that we do believe what is being reported, and we support the results of their findings.
Thank you. Thank you. If Tineke already added in the comment that therefore we need an EU criterion on the independence in the screening regulation, and perhaps with another language, I could also add that something that Commission might do is also recognizing lack of independence when it sees it from those mechanisms that claim to be independent. With that, Sirpa, your turn now. Thank you for your question.
I'll give it a go. My original question has more or less been already dealt with. It was about, how could we strengthen the existing mechanisms and the cooperation? Because we see a lot of excellent inputs here from civil society, from lawyers, various mechanisms, but there are so many of them. National level, we see fragmentation. At the EU level, we have a rather weak fundamental rights agency when it comes to border issues, or cannot deal with individual cases, not even really monitor, but more research. Commission said that they cannot really take action. I'm impressed with the European Parliament oversight role, and I think that's really important. I think the same applies at the national level. At least for Finland, we have huge fragmentation of human rights structures. I cannot imagine anybody really having the resources or even a strong mandate or culture to really go to the borders. And also, how would you know when to go? Because the borders are very long, 1,000 kilometers. So in some ways, I think we are just somehow playing around a bit and thinking of new mechanisms. Well, the new ones have been watered down. So in some ways, in my thoughts, it comes back again to just us being stronger in holding member states accountable. Because whatever we set up in various layers, unless the member states really would have the political will to give the resources and give the mandates, we end up producing ineffective measures, and even the courts are now ignored. So really, I think we're facing now a worse situation, and I think it just requires stepping up more the oversight. But obviously, we should also then have somehow more support from the society, because what I see now is Finland has been one of the better countries, and I see the securitization just taking over, and even very liberal forces, with some exceptions, are somehow now accepting, close the borders. It's all hybrid, it's all security. So I don't have really a solution, although I do think we should fight against the fragmentation and just try to create stronger bodies, whatever level it is, and continue the effective oversight by the European Parliament, our own parliaments, and Commission, if not can do directly, monitoring, at least should then really give funding for the mandates that we are constantly receiving, for the NGOs funding, but also NHRIs. We have now mandates for monitoring funds, absolutely no resources. There are new tasks coming from all of these various initiatives at the EU level. And I just doubt that there will be proper resources. So this should be one of the, I think, most important points, that there has to be strong mandate, resources given. Otherwise, what can we do? At the same time, I'm encouraged. Polish example, I've been there a couple of times. I'm very impressed with the Polish commissioner. Same with what Laura was doing as ombudsman. So at the national level, we still have very good examples, but we do have a problem with the member states. So this is something we need to increase the pressure. Sorry, no solutions, just thinking desperately, what else could we do? No, even we are now being ignored within the parliament. I'm in the parliament, and still tomorrow we will have a law that will be a direct violation of any international standards. And this is a pro-human rights liberal government doing it. So anyhow, I'll stop here because I'm sure others might have more positive inputs. But there have been good elements. So I think we really need to somehow find the lead, how to do this more effectively, instead of creating new things constantly.
Thank you, Sirpa, so much. I think your last point is very, timely and accurate. Nicola, I saw you raised your hand earlier. Do you still want to speak, or?
Just briefly before I leave you, thank you, Laura. I agree with Sirpa that we should also try to focus on what we have on national and international level. And I just wanted to go back in time in 2017 when Laura was the Croatian ombudsman. And there was this small initiative where Serbian and Croatian ombudsman cooperated on documenting cases of pushbacks and ill treatment in line with the Istanbul Protocol. This was a very brief initiative which lasted for 2 months, but I also believe that maybe this model, where the two ombudsmen or several ombudsmen in the region can exchange information and use their wider mandates, which allow them to access, I know with difficulties, but still, according to the law, allow them to access a lot of things, because NGOs cannot do this. So this initiative was, maybe I can even find it and put a link before I leave, was at one point a product of cooperation between Croatian and Serbian ombudsman. It lasted for a very short period of time because it was, let's say, very hard to work in this kind of circumstances. It's very hard to justify one ombudsman operating and collecting evidence on the territory of other ombudsman, but at the same time, maybe this can be also a good example on how the existing framework and existing mechanism that we have can be used. And of course, I wanted to mention one other thing is that I know it is hard. I know it is not easy to be in a position of the ombudsman, deputy ombudsman, MPM, employer of the ombudsman and the MPM, but the things went too far in my opinion. And it's easy for me to speak from the perspective of someone who is outside the system. But after 5 or 6 years, because for me, the landmark moment is 18th of March of 2016, and the EU-Turkey statement, when the game has started. I know that there are no resources, that there is no manpower, that there is a huge political pressure, but I know that it is possible as an MPM or as an ombudsman to go to one smaller border police station, and I would sit there for 24 hours. I will bring my sandwich, I will bring my water, and I will sit there to see what the hell is going on. And I know it's unusual thing, and it's always better if you have a cooperation of the police, but I would spend a couple of days or a couple of weeks to see, because definitely at one point, refugees and migrants would come and I would observe what is going on. I would have my camera, I would have everything. So I know that we need to build this, the border monitoring mechanism, but we also need some courage and maybe even some, fatal consequences for the employees. But if you decided to work in the independent institution, then this is your job and this is your task, because we have to balance, but we cannot allow ourselves to go too far. So this is the last thing which I wanted to say. Thank you for having me. I have to leave, and I'm sorry if I'm going to receive some reactions on this. I just wanted to share this with you, and I'm going to send the link for this small initiative that was designed between Serbian and Croatian ombudsman on the documenting cases of pushback and ill treatment in line with the old Istanbul Protocol because we got the new one, which can also be a very useful instrument. Thank you. And
thank you so much for your enthusiasm. And we have 4 more questions or indications to speak. Mrs. Moskalkova, Russian ombudsman is here with us. May I just kindly ask all the remaining participants that want to speak or ask questions that we have only 10 more minutes left, so please keep up to the point and very shortly. Thank you so much. Madam Moskalkova, you have the floor.
Уважаемые господа ведущие, уважаемые коллеги, искренне благодарю вас за приглашение.
I thank you for the invitation.
На обсуждение вынесен очень важный вопрос.
The topic we discussed today is very actual, especially today.
В моем аппарате создана специальная
независимая
группа по мониторингу соблюдения прав мигрантов.
For monitoring of the rights of migrants has been created.
Россия не квотирует количество граждан,
Russian Federation has not set any quotas for citizens of Donetsk and Lugansk People's Republics and Ukraine,
которые могут выехать на нашу территорию. В феврале в связи с резко возросшим количеством лиц, желающих приехать в Россию автомобильным транспортом, возникла большая проблема, связанная с необходимостью увеличения пропускной способности ряда пунктов пропуска. Я, как уполномоченный по правам человека, обратилась в компетентные органы. Сейчас данная ситуация снята. В настоящий момент в России подписан указ президента, упрощающий вопросы въезда в Россию, пребывания в России и выезда из России.
I'm sorry to interrupt. It's very difficult to listen to both languages simultaneously. Would it be okay if you sent a question in the chat, or perhaps for the consecutive translation, but really mindful of the time because we have only 8 minutes left? It is very difficult to understand because we can hear both languages at the same time. So,
thank you very much. Мы будем очень стараться уложиться в определенное время.
Yeah, we will try to use our time. We understand the situation.
Я хочу еще раз сказать, что очень важная тема сегодня обсуждается.
The topic is very important today that we discussed today. I would like to reiterate it.
Что в моем аппарате омбудсмена создана специальная независимая группа по мониторингу.
And in my office, a special monitoring working group, independent one, was created for the monitoring of the rights of migrants.
В России нет квотирования количества граждан, которые приезжают из Донецка, Луганска и Украины.
And Russia has not set any quotas for citizens of Donetsk and Lugansk People's Republics and Ukraine wishing to arrive at Russia. No quotas.
В феврале в связи с резко возросшим количеством лиц, желающих ехать в Россию, автомобильным транспортом.
In February, with regard to the increased number of persons wishing to enter Russia by cars,
возникла проблема, связанная с необходимостью увеличить пропускной режим автомобилей.
There was a problem connected with the necessity to increase the capacity of some cross points.
Я обратилась с этим вопросом в пограничные службы.
And I addressed competent authorities, border authorities.
И данная ситуация оперативно была снята.
And this situation was immediately solved.
В настоящее время в России подписан указ президента, который упростил вопросы въезда в Россию.
And nowadays, an order of the President of the Russian Federation has been signed, which simplifies the questions of entry into Russia, stay in Russia, and exit
иностранных граждан
for foreign citizens and persons without citizenship,
которые приезжают из Донецка, Луганска и Украины.
Arriving into Russia from Donetsk, Lugansk, and Ukraine.
Во время обострения ситуации в Ираке, Сирии и Афганистане Россия свободно принимала желающих прибыть за защитой. наше государство.
During the aggravation of the situation in Iraq, Syria, and Afghanistan, Russia freely accepted citizens of these states who wanted to come to its territory searching for protection.
Очень важно, что Россия не препятствует выезду граждан в другие страны.
It is very important that Russia does not create any obstacles for Ukrainian citizens to go to third countries.
С февраля по настоящее время в Россию прибыло 2,5 миллиона граждан.
Since February, more than 2.5 million citizens have arrived in Russia.
Ежедневно прибывает 20.
More than 20,000 citizens enter Russia every day.
Для того, чтобы снять препятствия, в России проведена миграционная амнистия.
And a migration amnesty has been carried out in Russia in order to minimize administrative measures.
И в отношении 3000 граждан из Донецко-Луганской Украины
and such migration amnesty has been carried out against more than 3,000 citizens of Donetsk, Lugansk, People's Republics, and Ukraine,
которые имели ограничения на въезд из-за незначительных нарушений,
who had entry restrictions before due to the minor violations of migration legislation.
Дано разрешение на их въезд.
I apologize for interrupting, but we are really coming close to the end of the discussion, and I understand how important it is for you to tell us your point of view and give us the information of the situation now that your office faces. But if you don't mind, we need to move on because we have other also participants that would like to intervene and ask questions. Having said that, if I can pass the floor to Hanna Marcinska, Deputy Ombudswoman in Poland, who also wanted to intervene. Please, Hanna, if you could also be very mindful.
Thank you very much. Thank you very much. I don't want to comment, well, this speech of Mrs. Moskalkova. We know the situation quite well in Europe, and we know that, well, Ukrainians are the victims of the war initiated by Mr. Putin. So, but my question is, well, I wanted to address a question to Milena. This is extremely important what you talk about. And well, my quick question is about the written report. You have a written report. If, well, you have prepared this report, please, if you are so kind to send this report, because it is extremely important for us to compare the situation and to, well, to address to statistical data. You talk about the statistics. And one more problem, well, according to the Polish Guard, we have in the last year 40,000 attempts to cross the border. According to Frontex, it is only 9,000 cases of the crossing the border. So you see the difference. And the last comment regarding the chat, well, the Commission decided to initiate the infringement proceedings, but regarding the fence, the construction of fence at the border and the violation of EU law, especially regarding the Nature 2000. Thank you very much for this excellent report and for our meeting. Thanks a lot.
Thank you, Hanna. Milena, do you want to answer briefly?
Thank you. Yeah, I agree. The devil is always in the numbers, and it is very hard to assess the exact number of pushbacks. And I think this is also the good indicator how much these procedures are actually being unfolding for years now outside of the official mechanisms that police should follow, because many pushbacks are not officially recorded, at least, even though we do have information that there is some backlog data in many of the border crossings. However, using, for example, the example of Croatia, even though we will never get the number of pushbacks from Croatian authorities because they say, of course, pushbacks are not happening. They do release some statistics from which you can see the real numbers. For example, when they say that they have been around 28,000 interventions with illegal migrants, and at the same time, there have been around 2,500 asylum applications. This makes you wonder where the almost 25,000 people disappeared, from the statistics. And this is actually then consistent with the reports of other police authorities in the border regions and of international organizations and us that say that, for example, Croatia is pushing back between 20 and 25,000 people per year. This similar thing methodology can be applied to other borders as well to maybe better assess. I will share now in the link the reports that we are doing, and also I'm happy to follow up in email with anyone.
Okay, thank you very much, Milena, for sharing the link. There was a question in the chat to confirm. So the speaker, the Russian speaking was Tatiana Moskalkova, the Commissioner for Human Rights, that is the Ombudswoman in the Russian Federation. And I'm sorry, Ms. Moskalkova, for interrupting you, but we are really short of time. And by that, there are also 2 remaining questions in the chat that we didn't have time to answer, but we can do that by email if it's okay with the participants. And with that, thank you so much for the very engaging and interesting discussion, as the overall webinar was. And I will pass the floor to Debbie Conner, Secretary General of NHRI, for her final wrap-up and closing remarks. Please, Debbie.
Thank you very much, Laura, and thank you to each of the speakers for the really rich interventions. And I believe that each of your interventions and also the comments from the floor really underline the seriousness of this issue and the timeliness of this NHRI report and webinar. Action is needed to address human rights accountability at borders, and it is needed now. There are so many reports and evidence of serious and systematic violations of human rights at borders. And yet we see insufficient action by both member states and the European Commission to address this. We heard today that borders are not zones where human rights don't apply. These are international standards that apply throughout, that states have voluntarily taken on. And they are minimum standards to ensure human dignity. And yet, not only are these standards not being respected, we also heard of cruel and inhuman treatment. We heard of torture and violent pushbacks. We heard of a lack of access for individuals impacted to basic information and effective procedures to enforce their rights. We heard about member states, even those that generally accept human rights standards, rejecting the application of these international instruments and even codifying them in legislation. At the same time, we heard how the European Commission, in certain circumstances, acquiesced to these actions by not taking sufficient action to address this systematic abuse. In this regard, we see how the very legal frameworks and regional mechanisms are actually being challenged at this time. So what are the impacts of this? First, and most importantly, this has impacts on individuals, migrants at borders who are already facing unacceptable violations of their human rights, and then even worse, are denied access to justice. But beyond this, we have seen concrete evidence of a further deterioration of rule of law in Europe. This is beyond the individuals impacted, but shows the systematic actions not to respect these human rights commitments, to refuse access for NHRIs and other human rights defenders to address them, and even attacks on these human rights defenders for trying to address the issues faced. This suggests truly a dismantling of the accountability mechanisms, including the right to a fair trial, and also a lack of respect to the authority of international courts and the very human rights framework at the multilateral level. This issue is critical in relation to borders, but it will spread. It will impact on other areas. We've already seen this. And if we don't take action now, this will become more serious, not only at borders, but also beyond. So finally, what actions can be taken? First, we've heard how NHRIs are undertaking monitoring and reporting, which is the first step in accountability. Beyond that, they're using their full functions to advise government, to take complaints of individuals, to use the courts, to provide training and to really promote a culture of rights. They also use the international mechanisms, and we heard that the UN mechanisms can be used more, and also that the EU could act further in order to address the systemic issues faced. We heard how civil society organizations, how lawyers and activists are critical to really making a difference, but they need resources and also protection from attacks. We heard the importance of individual migrants. They, of course, have to take some action to enforce their rights and often have to do far too much after a traumatic experience is faced. But beyond that, their lived experience can really be used to help to affect change. I really encourage, again, the participation of migrants in the design and implementation of solutions to the situation faced. And finally, as I'm speaking on behalf of NHRI, I would like to reinforce that NHRI will continue to support NHRIs in their work to address human rights and human rights accountability at borders. Excuse me. We will also continue to support their cooperation because often, of course, well, fundamentally at borders, two states are involved. NHRI will also continue to advocate to the EU for meaningful actions, particularly in the context of the new Migration Pact. Finally, NHRI will work in parallel and also in synergy on rule of law across Europe. We have a dedicated piece of work to this. We have dedicated work on migration, and we will ensure that these two pieces of work are brought together so that we can address the concerning developments. Of course, we look forward to carrying out all of this work in cooperation with you, our colleagues, our partners, and I'd like to thank you again for your participation at this webinar. I'd like to thank all the speakers again, and also our consultants, Laura and also Isabella. I'd like to thank the Secretariat staff, Gabriel, Clara, and Christos in particular. And so we will be sending you our report, which will be shortly released. We will take into account all of your comments from today, and we look forward to working together with you to address this serious issue, because it's only through working together that we will be able to make a difference. This webinar is now closed, and thank you all very much for your inputs. Goodbye.